Good evening, everyone, and welcome. My name is Pamela Amato. I'm the Vice President of the Ingham County Bar Association, and it is my great honor to moderate this evening's session with Judge Aquilina, one of our 30th Circuit Court judges. I want to welcome you all. We're going to have fun, and we are going to learn a lot from Judge Aquilina this evening. Our format is interactive, so you can ask your questions directly to Judge Aquilina. We are being recorded. The atmosphere is casual and fun, so if you have a beverage, feel free. Just remember it is being recorded, so some sense of decorum is appropriate. Judge Aquilina, do you want people to wait to ask their questions, or do you want them to ask while you're speaking about a particular topic?
I have no problem if they want to, when we're on the topic, raise their hand and we can just make it free flowing. I think that's a lot more fun than just everybody hearing me speak like in court. They gotta wait and this and that. And let's get rid of the decorum and have some fun and just toss out your questions.
Sounds good. Decorum out the window. Thank you, Your Honor.
Yeah.
So if you could start by telling us a little bit about yourself, off the bench if you're comfortable, and prior to getting on the bench.
So right now I have 5 children. I live also with my parents who are elderly and not doing so well. I have 2 puppies. I write novels. I do motivational speaking. I teach at Michigan State and at Cooley. And of course, you know, I have a full criminal docket now. We used to have court of claims and civil and criminal. They took court of claims away from us. Recently, I learned that may be coming back. And for a number of different reasons, I now have 100% criminal and Judge Stokes has 100% civil. I don't know if it's going to stay like that, but right now for multiple reasons, that's how it is. And I really enjoy criminal because we're always in trial mode. And what I found with my civil docket was because we have so many tools, mediation, case evaluation, most civil cases settle. And so I didn't like to be bored during that month when civil was supposed to go and never did. So I'm really happy being busy. You all know I like to multitask and I'm always doing a number of different things at the same time. Prior to being on the bench, well, first of all, I was a district court judge before I became a circuit court judge. I was the sobriety court judge in 55th district and had a really busy docket in 55th district. And prior to that, I served 20 years in the military as the first female JAG officer in the history of the Michigan Army National Guard. I had a private practice for, I don't know, about 20 years, and I worked in the legislature for about 10 years. So I've been really busy my whole career. I love doing multiple things at the same time. My hobbies are cooking and sewing and painting and writing. And so that's just a little bit about me.
Thank you, Your Honor. All right, if you could tell us a little bit about your actual courtroom, what's going on in the criminal court?
So I think what I'm going to address is what's going on now in this since COVID, because I hope you all know what happened before. And if you didn't, I'm always happy to tell you and to compare and contrast what happened before COVID. And now we have this sort of new normal with COVID, and there's going to be an afterlife of COVID. Right now, I am primarily still on Zoom. I do go into the courtroom once in a while if people want an in-person hearing, or there's a kind of hearing where we need to have it in person for whatever reason. And right now, primarily, I am on Zoom. And I had the first hybrid jury trial. And that was now several months ago. I've been trying to get in the phase where we can continue to have hybrid jury trials. And that's really my goal. How it is working in my courtroom now is we are on Zoom for sure on Tuesdays, 10 to 12 and 1:30 to 3:30. Sometimes the hours expand because, as you know, there's always delays. We do the same hours on Thursday. Wednesdays and Mondays, we may have some catch up or some other times that we're doing things. But then we also schedule Friday, 10 to 12, sometimes 9:30 to 12. The rest of the time we're doing paperwork, we're reading all your briefs, we're doing research. We find that there's a ton more paperwork with Zoom. And also we're trying to avoid that Zoom fatigue that we all feel so that we can stay energized on the computer, because there is that reality that we're all experiencing. So we try to break it up. I have now, because as you all know, and I know because I was in private practice, I know your drawers are filled with cases that want to be closed, that you want them to be closed. We can only live with our cases for so long, right? It doesn't matter if you do family law or criminal. At some point, we want a new client to walk in and a new issue, right? And I have just got this terrible docket now because we haven't had trials and people have not been interested in pleading, because for them, for those people, and of course, don't get me wrong, there's innocent until proven guilty beyond a reasonable doubt. However, there are a number of people who've said, and we know this, you know, I want all my rights intact, and they're not going to do anything until we force them to do something. And there are, of course, many people who want their day. They say they're innocent. The jury will decide whether it's innocent or guilty beyond a reasonable doubt. There are cases I've dismissed because evidence is gone, people are gone. There's been too many days in the jail, so that's starting to happen. But what ultimately I'm doing is really putting people's feet to the fire and saying, okay, we are nearing the time. I'm anticipating for sure going into trial in September. I'm scheduling back-to-back trials. If I have a slot open in July or August, I will have a trial. But right now what we're doing is cleaning up the docket because I have pages. And we're holding, I shouldn't say we, but the prosecutor's office is holding pretrials. And we're doing as many as we can on the record so that witnesses have to show, so that defendant has to show. If somebody doesn't show, they're bench warranted. It's one way to clean up the docket. And the other is to let them know that 4 to 6 weeks or 8 weeks, depending on the kind of case it is and how much time we need to get the jury in and the number of jurors and all of that. There's a hard line. There's an end date to the plea offer. So for example, if March 31st, or I guess that's past, let's say June 31st is, or June 30th is the last day they can plead, they cannot, then that, and they don't plead, that means they are going to trial. I will not take a plea on the day of trial. I have done that in the past. All the lawyers know that. They show up and we have backup cases and all of that. But right now, I want firm, locked in trial dates. So once the date goes and that offer was on the table, it is completely lifted off, and I'm choosing to not accept it because I don't want to play this game of let's wait out and see if the evidence can get spoiled. Let's wait out and see if the victim isn't going to show. Let's wait out. How many days can they keep me in jail and then they've interfered with my constitutionally protected right? How many lawyers can I go through? I mean, there's so many things that are happening. And so we really want the people who need to go to trial, who want the trial, to get to trial sooner. And the way to do that is for those people who are just waiting to plead to the last minute, to give them the last minute. And that is a change from in my courtroom. The other change is that as judges, and of course, thank you, Judge Jamo and Judge Stokes and Judge McCormick for showing up. And please chime in if you want to talk about differences in your or my docket. But we can only have so many people in the courthouse. And we're only in phase 2. We're looking to go to phase 3, and hopefully we'll eventually open up. But we have to be cautious and follow the guidelines. And so we are staggering trials so that we're having a number of, so we're limiting the number of people in the building. And you know, if I have a capital case, then I might need 100 jurors. And so it would be very difficult to space out 100 jurors. And what the process that the judges have pretty much agreed to is that when we're holding a jury trial in the building, the bulk of the jurors will be in the jury room downstairs on the first floor. And then the 14 jurors who are first called on the list will come up. And then depending on which judge it is, you may have one extra alternate or up to 6 alternates, depending on the size of the courtroom and the seating, so that we don't waste time waiting for everybody to come up the elevator. And if, for example, Judge Dragonchuk and I both had a capital case, that would be too many people probably in the courthouse. So I'm going to try to have hybrid trials, as many as I can until we're at full capacity, so that I have the jury selection on Zoom, and then we go into the actual jury trial in the courtroom on Tuesday. And I had the first hybrid certainly in our county, maybe in the state, I don't really know. But anyway, it went really well. And we learned a lot by doing that. I was also part of the program that the Supreme Court had where they invited, there were probably 80 or 100 people, from court reporters to judges to all sorts of staff people. And we did a mock hybrid trial. And I learned a lot from that. And my court reporter learned a lot from that. And my law clerk learned a lot. So we put together, and I'm happy to share those with anyone. We put together special jury questions, and we made sure I worked with Gloria, our jury clerk, and asked her to help jurors put wallpaper so that I have the judge's background, right, for my court room. And we went around and took pictures of the wood in the building so that the jurors would also have that wallpaper, whether it's wood or if they were in their home, or depending on the device, if you can't put a wallpaper on, they would then be in front of a white wall. And we did that because what we learned doing the mock one was that jurors, and they have the attention span sometimes of a gnat. It depends on the kind of case, right? And so if it's a really juicy case, they're all about listening, but not every part of every trial is juicy, and their attention just goes. And so what they were doing is actually saying, your curtains, they would look really good in my bathroom. Where'd you get those? And of course, that's the last thing judges and attorneys want to hear. We want them to totally be focused on our case. So I learned from that, and we made sure in the jury trial that I had that everybody had the wallpaper, and the jury clerk was just marvelous working with us and made sure that people could come in ahead of time, including some of the lawyers and just anybody who needed it, so they could practice, putting it on the wallpaper. We could teach them how to put on the wallpaper. The lawyers, we practiced with, and I welcome any of you to do this, whether it's on Zoom or if you have a trial in my courtroom, let us know you want to practice using the equipment, and we'll work with you. The court reporter and the law clerk are trained to help you so that when we're at trial, you are absolutely flawless in terms of using the equipment in the courtroom. And of course, we're always there to help you, but I know you all get nervous. I did as a lawyer too. You've got the jury all eyes on you, and sometimes things don't go right. So we're there to help you, but get in and practice. I certainly, on the lunch hours when we're not using the courtroom, it's not my courtroom, it's your courtroom. Get in, tell me you want to use it. We'll unlock it. We'll work with you. Same thing on Zoom. If you want to work on how to display evidence using the breakout room, finding out the rules, we'll be happy to meet with you and work with you. I also want to tell you that Zoom, as I understand it, and I'm not the end all be all in the Supreme Court or the Court of Appeals for that matter, but I have listened to them. I've tried to work with them on the hybrid jury trials and their recommendations and everything. And my understanding is Zoom is not going away. And my feeling is that there's no right to confront a jury. Your accuser, yes, but not the jury. So I don't have a problem doing the hybrid jury trials. And I think that to keep our dockets moving, we have to do that. And what we found was jurors liked it. I met with them afterwards, and we all asked them questions. They loved it. They said, look, I'm more comfortable doing this. Please keep doing it. I didn't worry about getting there on time. I didn't worry about daycare. I didn't worry about a lot of things that I was worried about prior. And the length of the time of the jury selection took exactly the same amount of time on Zoom than in my courtroom. And there is, because I don't think that the use of Zoom is going to go away. Of course, we all know the model rule of professional responsibility 1.1, which says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. You need to add Zoom into your bag of knowledge. If you can't use Zoom, you can't perform in front of a jury and in front of your client and in front of the judge and opposing counsel and the whole thing. And because now we've been using it, a year and a half, pretty much flawlessly. Of course, there are some glitches, but I think you need to know how to use it. And we are very happy to help you so that when we have a trial, when you do a motion, whatever it is, if you want to put up evidence, we're happy to work with you on that so that it is seamless. And you need to be mindful of things like how to use that screen, what to put up, double checking the evidence, having it pre-marked, making sure, because in practice, you know, I can't tell you that I never made a mistake in trial, because I did. I think we all do. You know, you put out that exhibit B and Jesus got some handwriting, hearsay. Oh my gosh. Well, it's easy enough to do in court because I see it or the opposing counsel sees it and says, yeah, no, we're not going to accept this. But once it's up on Zoom, you know, you have to lay the foundation. We have to get it in. And the jury's there. You have to be mindful. And granted, I'm not doing the trial on Zoom. I have had motions though, and evidence has been shown, films have been shown. So you need to take some care about what's going to be up there. But also, as you're having jury selection, there might be a case, especially if you have a civil case, medical malpractice, or if you have a criminal case, where you might want to show the jury that, you know, both sides know it's coming in, and say, you're going to hear a lot about this. You're going to see a lot about this. Would this bother any of you? And so you need to make sure that anything you put up is flawless. You don't waste time. It doesn't have any hearsay on it. And there are a lot of pieces to having that hybrid jury trial. A lot of changes in the jury instructions that I did about not taking pictures of evidence, not having anybody talk to you, not talking to anyone, not having anyone listen, not having any extra devices, because we all know right now I've got my computer up, I've got my iPad, and I've got my cell phone, and you all do too, admit it. I know you do. That's the way we are. And so we can't have jurors do that. And in fact, when we had the hybrid jury selection, there was a woman who was driving, and I said, ma'am, are you driving? And she says, yes. I said, when will you be home? She said, oh, soon. 15 minutes later, I figured 15 minutes. I can go to my kids' school and back in 15 minutes. I can run into Myers and back in 15 minutes because they're all close. I figured, well, maybe she's doing that. I didn't get into what she was doing, and I should have. I just believed her and just went on. 15 minutes went by, and I said, ma'am, are you still driving? Oh, yes. Well, when is your ETA? When do you think you'll actually go through the doors of your home? Oh, in about 2 hours. I'm driving home from up north. I said, you're excused. No one wants to drive next to you. So we have to, as we're looking at this sort of new normal and where do we go from here, you know, into the future, I think Zoom is here to stay. And we need to talk about all of those things, share the knowledge, and anticipate these kinds of problems without getting upset. Now, I could have gotten upset. And I could have said, go call, you know, and you're going to have another hearing, or I'm going to, and I didn't. I mean, we just really have to go with the flow. There are just probably a ton of questions on the hybrid trials I'm happy to answer. I think those are really the changes in my courtroom. I can tell you the other things that just some tips for my courtroom. I hate when somebody tells me, when I ask a question of a lawyer and they tell me what they think or what they believe, I tell them to go tell their partner, their children, or their mother what they think, and to take their beliefs to church. Got evidence? And I teach that in the students in the classroom as well. I want y'all to remember that as judges, the only thing that really interests us is evidence. So your opinions are interesting, and we'll all have a beer with you or a cup of coffee with you to talk about your opinions and your beliefs. But on the record, please bring me evidence. That's all I care about. Give me something to rule, give the jury something to rule, to make that decision that can be really tough. Your beliefs and your thoughts, God bless you. You know, I've got those too, but they have to stay, you know, where they belong. And it's just not part of evidence. At least that, and that's not 100%. I mean, sometimes I might ask you a think or believe, but I try not to do that. Offers of proof. Somehow 90% of the lawyers seem to have missed that day in law school. I didn't miss that day in law school, and it's a court rule. Your court rule is your Bible. If I kick out an expert or don't rule your way, and I say, would you like to make an offer of proof? Why are you looking at me blank-faced? That's your record to make. You make a separate record. If there's an appeal issue, it's your best record. So learn and offer proof. If you need a little lesson on it, I have a handout I give to my students. It's in the court rules. It's really easy, and it just makes a damn fine record. Motions for reconsideration. Use them. You can appeal me all day long. You can appeal any of us, but sometimes there's something that we missed, or a new case or whatever. Give us a motion out of courtesy. Just give us a motion for reconsideration. And again, read the rule, because 9 times out of 10, the attorneys will call my office and set a court date. And you don't get a date unless I say so. You don't get a responsive brief unless I say so. But motions for reconsideration are really valuable. And if it's just because you're unhappy with my ruling, then go to the Court of Appeals, please. I advise you, because I don't want to say, yeah, no new issues, and make me sign another piece of paper and kill another tree. That's really important. And attorneys have a bad habit of saying, strike that. And you know what? You can keep saying strike that if you're on your way to Hollywood. That is the only place it's entertaining. If you have a motion to strike, make the motion to strike and give the judge time to rule on it. So many attorneys will start a sentence and then they'll say, strike that. All you have to do is say, if you want it struck from the record, just say, Your Honor, I'd like to rephrase motion to strike. Judge is going to say granted. Otherwise, just calmly say, let me rephrase that. I asked a bad question. Let me rephrase that. So strike that might sound all powerful and all of that, but it's really a Hollywood move, and it means absolutely nothing in the record and just shows me that you're wearing baby diapers, baby lawyer diapers. So that sort of cheeses me off, just because it's just silly. The other thing is, all of us judges, and I don't usually speak for all 9 of us, but I think in this case, and please judges, chime in if I'm wrong, we want judges' copies. And we don't necessarily want you to give them to the clerk. I find judges' copies in the clerk's office that don't ever get to me. Under COVID, email it to me with all the parties, get it to my law clerk, drop it in my office, tell me it's there, whatever it is. We want judges' copies, and we don't want them the day of the hearing, and we don't want them the day before the hearing. There's a court rule. So and some judges wanted them, if it's really complicated, we might want it a month before, 2 weeks before, 7 days, 9 days, whatever the judge's preference are. We're all different in that way, but I don't want it the day before. And because I like to read it, I do read them, I research them. Sometimes I have my law clerk pull other cases, because I say, geez, if I know there's another case that's contrary, or that is even stronger than this. So give me some time to absorb it. You did the work. Your clients paid you. Let me use it. If you're not giving me the judge's copy in time, it means nothing. And if for some reason you stayed up all night, you had a sick kid or whatever, just call and reschedule so that I have time to read the judge's copy. If for some reason you're late, I don't like you to reschedule very often, because I like to keep my docket going, but life happens. If you're just honest with us and say, I need to reschedule, I think most judges appreciate that, and we'll do it because we know life happens. But please, we all want judges' copies timely. I don't know. Do you have questions at this point?
I do, Your Honor.
Yep.
For recordings, video recordings, audio recordings, how does the court like to receive those? Because in the family system, we provide our exhibits typically 3 days in advance, and to send a flash drive to the court, not accepted. So how should we get those to the court?
So, and I don't know, and various judges may have differing opinions. We have the capability for flash drives. We also have the capability for CDs. I would tell my law clerk or my court reporter what format it's in, and then we will get the equipment to match it up, because we do have in our courthouse, we do have different movable equipment. So if it doesn't mesh with my equipment, we can get a clean computer, a different computer. So and I don't get too involved in that. Usually, like if it's something from the prosecutor's office, they have a clean computer. So they will have shared that already, and then they'll bring the clean computer in, and they might even offer, counsel has stipulated to this, judge, would you like to see this ahead of time? So depending on what it is, I would contact the judge's office and ask. because sometimes the format you receive it in is the format you want to play it in. You don't want to copy it onto a different format because things change. And so I would just contact the judge's office, contact my office and ask.
Thank you. I have
Yeah.
another question.
Yeah, go ahead.
When you're talking about a hybrid trial, are you saying that the witness and the parties are in the courtroom and the jurors are present via Zoom?
Okay, I haven't been clear. So I do the jury selection only on Zoom, and everybody's on Zoom. Then once we have our 14 jurors, the next day we go into the courtroom and do everything like we normally do. All right. And so with a criminal case, you have 14 jurors. So my courtroom, and I think all of our courtrooms are outfitted for the most part. The seating is all 6 feet away, and we have plexiglass, and we have masks, and we have shields, and we have all of that. So there's only about, I think in my courtroom, about 4 seats for visitors. So if there's a case where there's going to be more visitors, we do have extra rooms that we can televise to for the overflow. We have overflow rooms because there are many cases that will have more than 4 visitors, right? So the other thing is for the virtual selection, what's interesting, Zoom has had a lot of different changes. So, you can change your name. We don't let anybody go on screen with their name. We have the numbers. So we put their number, and once they're called, because the jurors get numbers now with our new jury system as of a couple of years ago. So they might be jurors 769482. And then once they're called into seat 1, my law clerk will write seat 1. So it might be 769482-seat 1, so that the attorneys and myself and the court reporter know that that number goes with that seat. So we make a really good record. The other thing is that with so many changes with Zoom, they now can, so if you're looking at your screen and you want to organize the boxes that you see, you can actually organize them on most screens, whether it's by your arrow or by your finger, depending on what device you're using. So you can move the boxes to the 14 order, like you would be in the courtroom, seated, 1 through 14. So it really is good. Right now, and if I were in practice, I would want the Zoom jury selection simply because I can see the faces better. Right now, with the widespread seating, there's quite a distance in all of our courtrooms. I'm not sure, because one of the comments is, well, what about all the body language? Well, I want to see faces. The eyes, the soul is in the eyes. You're not seeing faces in the courtroom as clearly as I would want if I'm doing jury selection. I don't think anything's lost. I actually, my staff and I and the jurors preferred right now in how we're doing things, Zoom jury selection. And I'm going to do that unless I'm told I can't. And so far, we're getting the green light, as far as I understand, to do that.
Thank you.
Your Honor,
Yeah.
I have a question for you. It's about your experience. You mentioned that you've been giving motivational speeches, or you were a motivational speaker. I'm just curious what you talked about.
Yeah, so I talk about our own power. I've talked to a lot of judges across the country, and lawyers, and just domestic violence groups, and just a lot of varied groups, almost. And really, it's about owning your own power, using your voice, changing the world so that, I think the why question is, as lawyers and as judges, we should not be asking the why question. Why were you there? Why didn't you call? Why were you wearing that? Those kinds of things, because why shames and blames. And you're never going to get the kind of information you would if you say, can you tell me, what would you like me to know? From your perspective, what did you see? Rather than, well, why are you saying that? It was dark, wasn't it? Cross-examination has its place, but before we get to cross, we have to lay a proper foundation. And so I talk about those kinds of things, and it's even with children in my own house. 2 summers ago, we were up north, my kids and I, And I slept in a little bit and my twins started fighting. And my son came to me and said, Marissa stole my blanket. And I said, we have so many blankets. Why don't you just go get another blanket? And he said to me, point blank, you are blaming me. And I said, no. And I got up and I got him the blanket and smoothed it over. So in our own lives, the language that we use can even stop our children from not telling us the whole story. And if you think about it, when you came home from school as a child and your mother said, why are you wearing that? Why don't you have your homework done? Why are you late? You gave a short answer and you got the hell out of there, right? You didn't give the full story. So I talk about those things. I talk about using the proper body parts in our own homes, in our schools, in the courtroom, because, and here's an example, one of the examples I use, someone very close to me had a daughter and I'm like her mother, and she lost her mother years ago, and she had a young daughter, and she started talking to me about her tutu. And I said, you need an outfit? What are you asking me? And she said, no. She said, my dad always referred to vagina as a tutu. And I said, do you understand? I just thought you were talking about maybe putting her in dance or something, because a tutu is a dress, right? Some kind of dance outfit. And I said, you need to teach your daughter the right body parts, because how are you going to know if she's assaulted or she's hurt, or how is she going to be able to express herself properly? And so she did that. And then she came back to me a couple of years later, and here was the story of what happened. The girl is now in kindergarten, and the teacher says to the girl, to the whole class, students, draw a boy and girl. This little girl was the only girl to draw the boy and girl with correct, anatomically correct, with body parts. And everybody else put clothes on the boy and girl, except this girl. So that should have been a teachable moment. And the teachable moment would be, you know, we're all wearing clothes and you've done such a great job, right? You got everything just correct. So now can you draw some clothes? Like we're all clothed. And if you see anybody naked, please tell an adult. Now, what happened was not that. The teacher brought the little girl to the principal's office. The mom got called. And the little girl got shamed for drawing the correct body parts. This is why all of us judges have child abuse, child neglect, rape, all these assaultive crimes where people are shamed into not speaking about it. And even when they talk about it, they're using sometimes the wrong language because they don't know. So the kinds of things I talk about are really to empower people to use their voice, to listen, to ask the right questions, to know that they matter, to tell other people they matter. Because on the bench, I can tell you, I listen to countless people, defendants, not just victims, but defendants. And I tell defendants, you know, you did all of this. You can do better. I know you can. And what do you want to do? Where do you see yourself in 5 years? And so many of them can't tell me because they don't have a mommy and daddy like the rest of us. They didn't know that they mattered. They don't think beyond, you know, I need to use the bathroom. I need to have a warm blanket and some food. They don't think beyond that day. And so when I tell them, you know, you matter and you can do this. Oh, you want to be a librarian. You want to be an electrician, whatever it is. They come and I say, come back to me and show me the great things you've done. I have every belief you're going to do very well. And I'm really excited for you. Come back and show me the great things you've done. And they come back. I've had hundreds come back and tell me you were the first person that told me I mattered. So the motivational speeches that I talk about are really how we can make our judicial system better, how we can make ourselves better, our family, the language, and telling people that, you know, they really matter just the way they are.
Thank you.
Yeah.
Great.
Long explanation, but, and I could go on and on to topics, but you know, yeah.
Oh, yeah.
That's a little snippet. Yeah.
Are those available on YouTube, Your Honor?
Many people have taped me, sure. I also just started a podcast with a therapist, a social worker friend of mine, who we ended up a lot of speaking things together, and we sort of think a lot alike. So the podcast is Warrior Women Speak. It's nothing I get paid for. It's nothing, it's really just talking about, here's something I did for someone on probation, or here's what happened to my kid or my neighbor, and here's how I handled it. And then she'll say, well, that was good because, and here's the psychology behind it. And like on Mother's Day, we did a podcast about people, Mother's Day is hard for a lot of people. For some people, it's because they lost their mother. For some others, it was because they were abused by their mother. It's triggering. For some, because they'll never be a mother. So we talk about those kinds of things. And again, it's about empowering people because knowledge is empowerment. And so though that's on Spotify and Apple and all sorts of places. And many of the speeches I've done are somewhere on YouTube. I don't listen to them, but I know they're out there. So if you Google my name, there's probably too much out there. Any other questions?
Yes,
I know
Grace.
there's questions, huh? Yeah, Grace.
I did have a question about the deadlines for pleas. I don't know if you've had any deadlines that have already passed for those.
No, because the firm trials, because we just really went full force now back into phase 2, right? So, and we're looking at phase 3. So I have a couple of slots open in July and August for trials, but we're using really June as a cleanup. And the trials in September, we've got pretrials set. So if you have a pretrial in front of me, understand that's going to be, if it's called a final pretrial, it really is a final pretrial. So, and the prosecutor and we'll talk to you about that. And I've been warning most of the attorneys in front of me. So I think it's known, but I think this forum is good. And it will really keep the docket moving, and it will keep, I think, the attorneys more organized too, because it's really hard to get ready for a case and then, oops, it's not going today, and then you've got another one and another one. And we're just all over, we're all full. And the other thing is, so like if my courtroom's not in use, the other judges certainly can use it. And we're sharing jury rooms and we're keeping the spacing. Judge Stokes they're doing, I think, some construction in her courtroom finally, thank goodness. And so she may be using my courtroom. So it's also good to tell your clients, look, double check what courtroom you're in, or understand you may be in Aquilina's courtroom, but maybe you're using, you're also going to see Judge McCormick's jury room as well as Aquilina's, or she might be up, using both. So we're sort of playing musical rooms so that we can do the distancing. So if you need to tell your clients, and for all of you to know, if people are moving around the building, don't talk about your cases openly. You may be running into a juror or a witness because we're not taking them all through the back halls. I think we're going to do as best as we can. But again, it's a good reminder, once you are on that sidewalk coming in the building, don't talk about the case if it's something that shouldn't be heard by a juror.
Thank you.
Any other questions?
Your Honor, when new attorneys appear before you, what are some of the tips you can offer for new practicing attorneys?
Always carry a business card, have a stack of them. You should, if you're in the courtroom, make sure you're giving that business card to the court reporter so she gets your name and your P number and everything right. And spell it. If you have a name like Aquilina, just spell it. And everybody will eventually learn how to say it and learn how to spell it. But we're not all blessed with the name Smith. And so I think most people know how to spell Smith, but if you have a spelling of Smith and you add an E on it or a Y, or you've done something to it, please spell it so we know. Or if we say it wrong, just say, Your Honor, I pronounce it, it's not whatever. It's not Smith, it's Smythe. I mean, just tell us. And we don't mind. We like to say names correctly. I think as a new lawyer, bring your court rules. Sit in the courtroom and watch the older lawyers. I have had lawyers who have watched 10 pleas, and then they stand up and they don't know how to do a plea. And I'm baffled. What were you doing? Were you daydreaming? Why? Get into court early. We have on council tables, we have forms. You know, it's not a secret. It's there for you to look at. Open the files, look at it. It has the advice of rights. It has the appellate rights. There are some blank forms for motions. Look at it. Those are for your use. And if we need to refill it, let us know. If you want to take those home with you so you can have them in your office or whatever, go ahead. That's so that you make, so we can do things quicker. If you're unsure, I've had new attorneys come back, you know, don't be shy. We're not mean judges. We want you to ask us questions. At least I do. And I think my fellow judges do as well. I appreciate when a new attorney comes to my bench and says, Your Honor, can I talk with you? And if I have time, I'll take them in the back, or I'll just say, yeah, is there something? And sometimes they just say, this was my first motion. How did I do? Or what could I do better? And, you know, I really appreciate that, because you should never, when your ego gets too big, you ought to just retire and go pour coffee. I don't think as lawyers, we have big egos, right? We get torn down all the time, even as judges. And so, you know, just be humbled enough to say, you know, we're all in this together. How can we make it better together?
Thank you, Your Honor.
Your Honors, is there any update about the June 7th date? I understand that there was some optimism that we may be able to open things up a step further around June 7th. Is there any update on that information?
As my understanding, we are looking toward that date. The numbers we were looking for, and I wrote that down. I don't know if I have it in front of me, but any of the other judges can jump in. Things are opening up. We're planning to have trials. We are looking to even opening up further. I don't think we're going backwards. I think we're going forward into phase 3 and hopefully into phase 4, but we needed to have, I think, a 65. There's a bunch of different factors, like 60 right now. I think 57% is what the numbers I heard last of our counties vaccinated. I think we need 65% vaccinated. And then we have to have the hospital beds and the COVID rate, you know, down below a certain number. There's all these factors. But as far as I know, we're on the right path, and we will be doing trials as early as June. I believe Judge Kennedy has already set some for June. So we are opening up, yes. And in fact, there are some motions. I'm not doing trials probably in June or July, but there's some motions and other things that need to be in the courtroom. So I will be returning to do those kinds of things and then doing those final pre-trials, many of them in the courtroom and some on Zoom, heading toward, you know, the trials in August, September. Does that answer your question? Any judge want to jump in and tell me more info, or tell them more information? Did I get it about right, Judge McCormick?
Yeah, I think that's right. I mean, the numbers are looking good, and it looks like we're going to get started on June 7th. So, you know, it's still fluctuating, and it's still a constant moving target, because you never know, but it seems like we're headed in the right direction. So as it stands right now, we're starting, but
Yeah.
you know, tomorrow could be a different story. So you just have to keep posted.
Right. And we have a master list as judges. So we are all, you know, I think it's unusual for our bench to work this well together on things like this. And we have a master list. So we're working together so that we're not stepping on anybody's toes. Everybody's getting different days. And so you will look like, if I'm not having hearings, you know, Judge McCormick can use my courtroom. I've already told her that, and Judge Stokes. I know Judge Jamos chimed in. And so we're working on a master calendar so that we're making the best use of our space as we open things up.
Okay, thank you. So all things look good, and we don't expect a continuation of Judge Garcia's earlier order, saying, correct?
That's what yes, that was the word we had. But, you know, this thing has changed so many times, who knows? But yes, we are looking to opening up and then opening up further.
Okay, thank you very much.
Yep,
Pamela. Thank you, Your Honor.
And you may want to just come check out the courtrooms if you haven't been in the building, because it is very different, and it will be something everyone has to get used to. So just, it looks very different, at least on the 3rd floor. The 2nd floor hasn't really been done except Judge Dunning's courtroom, but the 3rd floor, you should check it out if you've got a case coming up, because it's going to be a little different for you.
Yeah. And we are doing and I think all the judges are doing this, but again, I'm not in all of their courtrooms. But when I'm in the courtroom, for example, if my court reporter couldn't come in or wasn't feeling well or what have you, or if we have a witness, or if somebody's in out of state or whatever, we're having them, even though I'm in the courtroom, they're in on Zoom. So we've got all the functionality of Zoom We don't all have to be on Zoom. We can still be in the courtroom and bring people in, witnesses and what have you. So we're hoping that with now the functionality that all of that will be positive. The other thing that I've added in my courtroom is a color printer. So we have those screens, the touch screens. So if you have, let's say, a layout of, if there was a bank robbery or something, and they say, well, I was standing here and I was standing here, if there's on a diagram. So that might be exhibit 12. So now they've made the little X's of where everybody was standing, the witness has. So now that will be printed, and that would be like exhibit 12A. So now you'll have that exhibit to go along, that modified exhibit, just as it was done by the witness. So it'll go along with the transcript, and that will make the best possible record. I've been asking for it and finally got it. So that will be a change, and I think for the better.
And that's just unique to your courtroom, Your Honor?
I don't know if any, I used to have Judge Jamo's courtroom when I first got elected to the 30th Circuit, and they did have that capability. And then that broke, and then I spent the last, 10 years or 11 years asking for it. So I'm just getting it. I don't know that any of the other judges have asked for it or have used it. Maybe now that I'm saying this, they'll put it on the list as a want, because it really
fair.
Yeah, it really makes the absolute best record. And, it's one of those things I learned because I teach trial practice, and it's just one of those things. And I said, well, why can't we print this? Because it's always bothered me that we have this wonderful trial testimony and the jury gets to see it, and then the appellate court does not see it. They sort of have to guess. And of course, we do our best when someone says here, and then they describe, well, it was about 2 feet from this, and this is going to represent this or that. But you really see visually, what they're saying along with the picture they drew, and is that credible or incredible? And I think it makes a huge difference. So that is a change in my courtroom. So I think all the judges should order it. Hey, Wanda, nice to see your face. Any other questions or comments? So if you don't have any questions for me, and I know there's 4 judges on this, so half our bench is here basically. Is there something that the judges do that drive you crazy? You can be honest, we're all friends here. I won't hold you in contempt. I know I've been known for that, but I promise not to.
Pam only made a swear word once on the record, but it was completely unintentional because her Zoom failed. So
Yeah.
It was at the very beginning of us using Zoom. And I didn't realize that Judge McCormick and opposing counsel could hear me.
Yeah.
I'm glad it was just one.
that I heard anyway.
Actually, from my perspective, we have an amazing bench. It's always refreshing to be treated with respect by the judges, because I think the majority of us try to do our very best. And sometimes we don't hit the mark, and when we don't, it's really nice to always be treated with respect. And these sessions are amazing. I learn something every time, and for the judges to give us their time, I'm very grateful.
Yeah, I think we have an amazing bar that appears in front of us. And I don't want to disparage the rest of the state, but, I can always tell when there's an outsider who comes in, and I think we all treat them the same, but it's pretty interesting to me, the way that our attorneys get along and are prepared. And then other attorneys from other counties come in, they haven't looked at the court rules. They don't know what we do. They don't give us judges copies. They don't look at any of the things that we try to do to make our bench better. And so I think our attorneys overall shine.
Thank you, Your Honor.
Yeah. So any other questions? Certainly, as we move into hybrid, if you want copies of any of the jury instructions that we've done, I mean, obviously they're not perfect, but you can see some of the things we talk about. And you might have, I mean, really as a bar, it would be really great, I think, to have the bar look at some of the jury instructions that we've used and make comments and say, overall, this is good, this is not, how about this? Do you have problems with that? So that as judges in our county, we could develop some workable, uniform, or as uniform as possible, given the different kinds of cases we handle, jury instructions for hybrid jury selection. Because honestly, or even hybrid motions where you're going to have witnesses, because you have to think about, do I need to sequester the witness? And then we need to have put them in a breakout room. How are we going to handle that? We even have to think about that. We've put witnesses in a breakout room for hearings so they can't hear the hearing, and then pull them out one at a time. So it would be really nice maybe if the Ingham County Bar Association could work with us judges about how to best use Zoom best practices for holding motions and hearings and jury selection on Zoom, and then going into the courtroom, the best practices. Now, as judges, we sort of, as I said earlier, have this practice of if you're having a jury, pulling the 14 people plus a couple more because it saves some time. But maybe that's, and we have the overflow rooms, but maybe the bar hates it. Maybe there's a reason you want something different, because we should hear about it and maybe have some uniform policies. I think that as judges, one of the things that has really come good of this in our judges meetings is that we talk about these things and try to make it more uniform so everybody understands. So I think the input from the bar to us would be great.
Rose, I don't want to, I know I joined here a little bit late, but did you talk about the stakeholder meetings, or is it too early for that to talk about those yet?
I didn't talk. Do you want to talk about them? I didn't really talk much about the stakeholder meeting, but I sort of talked about what the outcome was of what we're doing, but go ahead.
Okay. No, I don't want to confuse anything. I think you've done a great job of explaining where we are and what's going to be happening as we try to open. I just didn't know if you had discussed that earlier, and it doesn't really work for my court because every one of my cases have different parties.
Yeah.
So it's not something that really applies so much to me, but I know for the criminal cases it does.
Yeah. Jim, any comments? Did we miss anything?
Okay.
Yeah.
I knew she didn't. She's so thorough.
Well, I don't know. I mean, I just sort of talk. I think people get tired of me talking. I try to be quiet at times.
Your Honor, I had one more question based on what you just talked about. You mentioned sequestering witnesses, and then you also said, don't say why because it's blaming. What's a tactful way to ask a sequestered witness under the Zoom conditions? Are you answering the questions without assistance? Do you have someone on the telephone helping you? How do we ask those tactful questions so we know it's just the witness answering?
I think that for a juror, especially, remember, we're all lawyers and judges. We're trained, we've been in this arena for quite some time. And for the public, they don't know the reason that they can't have somebody assist them, right? So I think the best thing to do is to say, and to talk to them as a group. And that's part of what I've got in my jury instructions, that we can't have, the decision has to be made by you, and at the right time you will be able to talk to your fellow jurors, but we need you to be answering the questions and not have other people talking to you or interfering or talking with you, because then the lawyers won't know and the judge won't know. And so I think if you give them the foundation of the how the process works, and then you can, if they're in a breakout room and then they're coming to be a witness and you say, or they're a juror and they've taken a break and now come back, is there anyone who had the opportunity to talk to someone during the break? Did anyone talk about the case with anyone? Is there anything you would like me to know? And just leave it wide open for them. But that answer then will come from the foundation that you've laid, the explanation of, how this works. Does that make sense?
Yes, thank you.
Yeah. And there's another term that recently I've started talking about too, and that is, the word if. If you talk to me like that again, then I will. So there's that consequence. And I think that if is really harsh. So it's always best to turn things around to say, when you talk like that, people don't listen to you, or it's hard for me to understand what you're saying. So if you talk a little softer, or if you are a little, when you are a little kinder, so you get rid of that if and you say when this happens. So you turn the if to a when. It's a little bit softer and kinder, and you get a better result. People are open then to listening.
Thank you.
And I think we need to just practice that, especially with jurors.
Judge Aquilina, I just wanted to weigh in with regards to the model jury instructions. Here, I can throw the video. With regards to the model jury instructions, I sent you an email. I'm willing to work with Public Defender's Office, Prosecutor's Office, and other relevant stakeholders to help to work on those. So appreciate you bringing that up, and I think that's a project we'll happily take on.
Yeah, well, and I've got, half our benches here. So we haven't really talked about doing that as a bench, but anybody object to working on this? I think it's really important because I think it's here to stay. And I think that working with the brilliant attorneys that we have and the various divisions, so we have, Judge Jamo has civil and criminal, and Judge Stokes has just civil, and I have just criminal, and Judge McCormick has family, and you have some probate too, right? Still there, you're still, yeah. So we can work on some model instructions. I think we'd all be better for it. And then we would have fewer appeals, because I can see in the future some appellate issues. So.
Okay, I think we are at our 1 hour. Your Honor, thank you so very much. Thank you to the participants and the judges that have participated via Zoom. And again, thank you so much. I think we learned a lot. I know we did.
Thank you. Yeah, well, thank you all for caring enough to do this. We're all in this together, and we should do this more often, not just because of COVID. So thank you all for your time and patience.
Thank you, Your Honor.
Thank you.
Great job, Pamela.